Wait a minute. I've got the wrong one. Okay, but I've got Garcia signed. Okay. Now, to Mr. Goto.
Yes, Your Honor, I'm here. How are you?
Yeah. I just said that, yeah.
You ready to proceed, Patty?
Yes, sir.
All right. The court calls case number 6.
Your Honor,
Yes, ma'am.
Mr. Goto needs to just mute himself until he speaks because of the background noise.
Yeah,
So I muted him.
very good. Do you understand what's going on, Mr. Goto? All right. Court calls case number 653477, State of Texas versus Brandon Goto. Mr. Goto, please raise your right hand. When I ask you questions, make sure that you unmute just to answer that, okay? Now you raise your hand. Do you solemnly swear that in this proceeding, the information and responses you submit will be the truth, the whole truth, and nothing but the truth? All right, you need to unmute. Patty, can you unmute him? All right. Did you hear my question, sir?
Yes, sir, I did, and I do.
All right, very good. Go ahead, put your hand down and go ahead and mute while we speak. Mr. Goto, in this proceeding, this is a criminal proceeding in the state of Texas. Therefore, it's required of me to talk to you about some very basic and important constitutional rights that you have. The first right that you have is the right to remain silent. That means you do not have to make any kind of statement. You don't have to answer questions. You don't have to submit paperwork, especially papers that have your signature and confess or admit to wrongdoing. Do you understand you have the right to remain silent? All right, you're still muted.
Yes, sir, I do. I understand completely. I trust in my attorney, and I know she has my best interests in her mind. Thank you.
All right, I'll be asking you questions and you can answer them.
Sure.
Secondly, you have the right to a jury trial. That's 6 people selected from a random pool of people with your help of your attorney and with the state participating. Those 6 people would hear the evidence in this case and decide if you were guilty or not guilty. Do you understand you have the right to a jury trial?
Yes, sir, I do understand.
All right. Now, you have the right to what's called the confrontation of witnesses. Those are big words. What it means is that you and your attorney would have the right to question, cross-examine, or challenge any witness who would want to testify if you went to trial. That's called confrontation of witnesses. Do you understand you have that right?
Yes, sir, I do understand.
There's also a right called the right to appeal. After all is said and done and the proceedings are over, you and your attorney together, or you alone, or your attorney alone, would have the right to demand that a higher court review the official record in this matter, which is being prepared by a court reporter, Ms. Rivera. You'd have the right to review that official record and the evidence in this case, that is, have the higher court do that review. Now, that's essentially what's called the right of appeal. You'd have to follow the time limits. You'd have to follow and use the right paperwork. You understand that you have the right of appeal?
Yes, sir, I do.
All right. You also have the right, it's called the right to have this hearing in a public open courtroom. You and the state both have individual rights to do that. In this case, because of the pandemic, we're not doing a open courtroom hearing, we're doing it by video conference, but that has to be approved or agreed to by you and by the state. You are at this time being broadcast on YouTube, but understand that the right is to demand a courtroom hearing. You understand you have the right to have a courtroom hearing, open public courtroom.
Yes, sir. I understand.
All right. Now, those rights that I've just mentioned to you, those rights, if you persist in a plea, are considered waived, or that you're giving up those rights. Are you giving up those rights?
Yes, Your Honor. I am giving up those rights to proceed here.
All right. Now, I'm going to show you a bunch of documents, court documents on this case. Each one is going to have at the top what I call identifying information, with one or two exceptions, actually just one real exception. Those that identifying information, if you look at the screen, shows cause number 653477. The state of Texas versus Brannon. Is that spelled correct?
Yes, Your Honor, it's Brannon.
Okay. Seiji, S-E-I-J-I, Goto, in County Court of Law number 5, Bexar County, Texas. Now, below that identifying information, all the documents will have will be identified. This case is state's consent to video conference. It is in bold print, all capitals. This one is, when I explained to you a while ago, the right to a public courtroom hearing, the state has that right, and so do you. What you're being shown right here is that this document is signed by Andrew Harris Edelman, the Assistant District Attorney, that he agrees, he consents to the video conference. Do you see that paperwork?
Yes, sir, I did.
Now, the next document I'm showing you, again, the identifying information. This one is titled Discovery Acknowledgement. There's a law that's called Article 39.14 of the Code of Criminal Procedure. That law requires, and the state of Texas requires, that the district attorney's office share with you and your attorney the information, evidence, materials, receipts, videos, whatever they have, so that you and your attorney can make an informed and intelligent decision in this matter. This one is signed by your attorney and the assistant district attorney, both of them declaring that, yes, that law has been followed, that they provided the discovery or information and evidence. Are you aware of this document?
Yes, sir, I'm aware of the document.
All right. Now, the next one is your own. This one is where you you have the identifying information. Then this is the defendant's consent to video conference. This is the one where you say, yes, I know I have the right to do this in a public courtroom, but I'm giving up that right. And you've signed it, so has your attorney. Is that right?
Yes, Your Honor, I have signed it.
Okay. The next document, again, identifying information at the top. This one is titled Defendant's Waiver of Constitutional Rights and Court's Admonition. Did you carefully review this with your attorney?
Yes, sir, I did, and I've read it over.
All right. Now, it starts off with 3 basic sentences. The second sentence says that you know what you're charged with, which is DWI. The third one says, I hereby enter a plea of nolo contendere to the charge of DWI. Is that true? Is that what you're doing?
Yes, sir.
The rest of this document is divided into 15 numbered sections or divisions. The very first one, number 1, talks about the punishment that you can be given for this charge. The very first box at the top of a list, or rather is a group of little boxes that are stacked up vertically. The very first one is checked off.
Yes, sir, I've read.
DWI first, you can be punished with a fine from $0 to $2,000 and in jail from 72 hours to 180 days in jail. Did you see and understand the range of punishment?
Yes, sir. I've read and understand completely, 100%.
All right, I want you to read to me number 2. Read it out loud.
I understand I have a right to a jury trial, a right to cross-examine a witness, and a right to remain silent. I freely and voluntarily give up those rights.
All right, is that what you're doing?
Yes, sir, I am.
All right. Number 3 talks about mental health. Have you ever had any mental health problems?
No, sir, I have not.
Have you ever been given or taken mental health medications?
No, sir, I have not.
Say again?
No, sir, I have not taken any
Okay, very good. Now you've read all these. One thing I need to ask you: have you ever been involved in the sex offender registration program?
No, sir, I have not.
Good. Number 8 talks about U.S. citizenship. Where were you born?
Honolulu, Hawaii, sir.
That makes you a U.S. citizen, right?
Yes, sir, it sure does.
It is so noted on the record. All these other paragraphs, they're all important. One in particular I want to draw your attention to says that you've made a deal with the state. It's a plea bargain.
Yes, sir.
As a judge, it is my authority and responsibility to either accept your deal or reject it. I have to do that. I have to assess a punishment in the event of a plea. If I reject your deal, or if I give you a punishment within the proper range, but heavier than you agreed to, in that case, the law would allow you to start all over, and nothing you've said or signed up till now would be used against you in that event. Did you understand that?
Yes, sir, I do.
Number 15, all of these you are waiving by signing this document after having reviewed it with your attorney. Number 15 says that you have the right to demand a risk and needs assessment. Obviously, you reviewed this with your attorney. Are you giving up that right?
Yes, sir, I am.
All right. And it has a signature, your attorney, the state's attorney, and yourself. I will be signing that myself. The next document here is a document that I am doing a certification. It's titled Trial Court Certification of Defendant's Right of Appeal. Again, a stack of little squares, small boxes. Each one has something different to say about the right of appeal. The 5th one I will be check marking. It says, and this is my certification to you, this is a plea bargain case and the defendant has no right of appeal. Are you aware that that's the correct certification that I am making?
Yes, sir, I understand.
All right, I will be signing that. It already has your signature and that of your attorney. The next document will be what's called a plea agreement. This is the final deal. It's got to be reloaded into the computer, so give us a moment. Ms. Enriquez, will you quiet down, please?
I don't want to mess up your perfect record.
I'm sorry?
Said I don't want to mess up your perfect record. You're doing a fantastic job.
Your Honor, I don't have any other paperwork for him. I don't have a plea agreement page. That's all I received, just the paperwork that I just showed you.
Give me a moment to fix this, Your Honor.
Certainly. And Ms. Tea Santos, I see you there, so just relax. We'll be with you in a little bit.
Ms. Garcia, you'll receive it soon.
I got it. Ready, Judge.
All right. Mr. Goto, this document is titled Plea Agreement. It's a little bit different from the others in that the identifying information is subsequent to the title of the document, and it does not say County Court of Law number 5. Otherwise, the identifying information is the same. I will be checking that first box. That one talks about, again, the particular and important right to remain silent. Then the second box I will be marking that identifies you as a U.S. citizen. The next section says defendant's acknowledgement. There are 5 small squares, little boxes, with all of them check marked. Making declarations again about the different constitutional rights and protections that you're afforded and that you have waived or you are waiving. Did you see that information that's got the 5 check marks there and understand it? And is it accurate?
Yes, sir, it is.
All right. Now, in this this next section is a DWI specific allegation. This is the state will proceed with DWI as alleged in the charging instrument.
Yes, sir, I did see that.
All right, if you'll scroll it, Patty. To the charge of DWI, that is misdemeanor B, how do you plead, sir?
No content, sir.
All right. Just so you're aware, a no contest plea is considered a guilty plea by this court and is sufficient for me to convict you. Do you understand that?
Yes, sir.
Question? All right. Based on your plea of no contest and the evidence, I find you guilty. Now, I am ordering you to come to the, let's see, Patricia, is he allowed to place the thumbprint there at the jail? He doesn't have the documents with him there, does he?
I'm not sure, Judge.
Well, he doesn't have the original, so he's not. Mr. Goto, I order you to appear here at the offices of County Court of Law number 5 within 7 days.
Your Honor, if I may, he will be in custody potentially until July on some felony offenses.
Okay.
And Your Honor, that is why on the plea agreement form, I wrote it as appear to comply with CCP 38.33 when he is released from custody, because we don't know at what point he will be released. And it does not seem fair to order him to appear within 7 days when he is not physically capable of doing so.
Obviously, you're correct. So, Mr. Goto, once you are released from Bexar County Jail, from that date, you have 7 days to appear at the Bexar County Courthouse Justice Center in the offices of County Court of Law number 5. The purpose will be simply to have your thumbprint placed on the original documents in this matter. It is a requirement of law. You understand that?
Yes, sir, I do.
All right. I have found you guilty. I sentence you to 121 days Bexar County Jail. 0 fine, 0 cost. Credit You're granted credit for time served, time and money run concurrently. The court finds that you have satisfied this judgment. Therefore, on this particular case number, you no longer owe anything to the state of Texas and to this court, with the exception of your thumbprint on the documents. Good luck to you. Stay out of trouble, young fella.
Thank you, sir, very much.
Ms. Enriquez, any questions?
Nothing further, Judge.
Mr. Goto, any questions?
No, sir. Thank you very much. Appreciate you.
Mr. Ailman?
Not concerning this proceeding, Your Honor.
All right. Then Ms. Enriquez, Mr. Goto, y'all are excused at this time.
Thank you. Have a great weekend, Judge.
Y'all too, stay safe.
Thank you for all your help, Andrew
You're welcome.
and Patty.
Welcome.
Bye.
Your Honor, may I be temporarily excused?
Yes, you may.
Thank you, sir.
Now, Ms. Dea Sanchez, what is your purpose in visiting with us? Are you here in the replacement of Maricela Luna? I don't hear you for whatever the reason. Patty, is Ms. Dea Sanchez replacing Maricela Luna today?
Yes, Your Honor.
Okay. Here I thought it was somebody named Chloe Dea Sanchez Santos, rather. All right. Joe Stenberg,
Howdy, neighbor.
how are you?
Fantastic. I'm here on Miranda Reyes. We have
What's her name?
last name is Reyes, first name is Miranda. She has 2 cases, both of which are going to be taken care of by pretrial diversion. She's already been approved by the Assistant DA, Caitlin. However, my client did not appear last week, and I don't see her here today.
Well, it's going to be a bit of a problem then, isn't it?
Yes, sir, but here's my situation. I explained to her that you're kind of persnickety about being on time. And I've got an email from her dated May the 5th. Yes, sir, I will make sure to be on Zoom by 9 o'clock. That's my understanding. So I've done all I can do.
I hear you. Well, we'll give you 1 week to find her and have her contact us. Otherwise, there'll be a warrant issued for her. And I would expect that it might jeopardize her PTD.
Yes, I understand.
All
By
right.
contact, did she just appear in person in the courtroom?
Yeah, that'd probably be worthwhile.
Okay, thank you. Bye-bye.
Take care. Stay safe.
And thank you, Patty.
You're welcome.
Now it is 10:29. We have 1 minute for Ms. Valenzuela to show up.
She's logging on now, Judge.
By golly, talk about being prompt. It's exactly 10:30. Who is it? Good morning, Ms. Valenzuela.
Good morning, Your Honor.
You ready to proceed?
Yes, we are.
All righty. Mr. Ovalle,
Yes, sir, I'm here.
good morning to you.
Good morning.
In fact, Mr. Ovalle has been a little early. He's been here at least 10 minutes. Mr. Ovalle,
Yes,
you
sir.
ready? you ready to proceed with this matter?
Yes, sir.
Would you raise your right hand?
It's right, sir.
Judge, I'm asking him to start his video.
I could see you earlier. Where did you go? There you are. All right. Nope.
Am I there?
Your
No.
voice is, but not your face.
Stop. It says your microphone is muted, unmuted. Your video has stopped.
The voice is all right. It's the video you've got to get on.
The host has asked you to start your video. Okay.
There.
There you are.
Okay. I can't see y'all though.
Joe Stenberg, you're excused unless you want to just hang around a little bit.
Oh, I'm trying to leave. Adios. Bye-bye.
Bye. Boy, he got out of here fast.
Sorry, I'm outside. They let me. I'm
I-
doing yards, but I got an hour.
I do see you now. Hold your right hand in front of your face a little bit. Right there. Do you solemnly swear that in this proceeding, the information and responses you submit will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Thank you. You may put your hand down. Mr. Ovalle, in this proceeding, you have some very important constitutional rights and protections. I want to discuss them with you verbally. They're being taken down on an official record prepared by Ms. Rivera. She's a court reporter. Those rights will also be repeated in writing in documents that you should have reviewed and signed. The first right I want to talk about is the right to remain silent. That means you do not have to make a statement of any kind. You don't have to answer questions. You don't have to submit paperwork that has your signature, especially papers that admit or confess to wrongdoing. You understand you have the right to remain silent.
Yes, sir.
You have the right to a jury trial. That means 6 people picked from a random pool of jury members that would be, the 6 would be selected by you and your attorney and by the assistant district attorney. That is a right wherein the 6 people selected would hear the evidence in this matter and decide whether you're guilty or not guilty. You understand you have the right to a jury trial.
Yes, sir.
You have the right to what's called confrontation of witnesses. That means you and your attorney would have the right, if you went to trial, you'd have the right to question, challenge, cross-examine any witness who would be coming up to testify. That's the right to confront witnesses. Do you understand you have that right?
Yes, sir.
You have the right to what's called appeal. That is a procedure that is subsequent to the trial or a plea. You have that right yourself, or your attorney could do it for you, or the 2 of you could do it together. You'd have to use the proper forms and be aware of the time limits that would be involved. That right, you would demand that a higher court review the official record and evidence and results so that you could make whatever challenge you wanted to. That's the right to appeal. Do you understand you have that right?
Yes, sir.
Now, the right I'm talking to you about now is called the right to a public trial or public hearing. That right, you have it, and also the state has it. They're individual rights. That right is to have this hearing in a public courtroom, but because of the COVID pandemic, it's not being done right now. Instead, it's being handled by video conference. In particular, the video conference at this point is being broadcast on YouTube, which is a public media. Do you understand you have the right to have that done, or rather to demand the hearing be held in a public courtroom?
Yes, sir.
And just again, the state has that right also. So
Okay,
now I'm
thank
going to show you a bunch of documents. The Each of these documents, with one exception, will have the identifying information at the top. Cause number 6411065, the state of Texas versus Mike Jonathan Ovalle in County Court at Law number 5, Bexar County, Texas. The title of this particular document is State's Consent to Video Conference, and it is in all capitals, bold print. This one is where the state has approved the video conference presentation. It is signed by Mr. Andrew Harris Edelman, the Assistant District Attorney. The second document I'm showing you is called Discovery Acknowledgement. This is a particular law, and it tells you right there in the first sentence, it says Article 39.14 of the Code of Criminal Procedure. This particular law requires the prosecutors, the state's attorneys, to disclose, provide access to receipts, documents, videos, whatever's involved, so that you and your attorney can make an informed and intelligent decision or choices. Do you see that document?
That one's actually not popping up, that document.
I'm sorry?
I can't see that one visually.
Did you review the documents with your attorney?
Oh, yes, sir. I'm sorry about that.
Okay, this one is called Discovery Acknowledgement. I just told you what it is.
Yes, sir.
It appears to have your signature. Did you sign
Yeah, I
it?
saw it. I'm sorry.
All right, no problem. All of these are made part of the record, obviously.
Okay, sorry about that.
The next document is yours, your own, where you consent in writing to the video conference. Did you review that with your attorney and sign it?
Yes, sir.
All right. Then we have a very important document. All of them are important, but this one has particular importance. It's called the Defendant's Waiver of Constitutional Rights in Court's Admonitions. That's a mouthful, but what it says, of course, it has the identifying information at the top. Then it has 3 separate sentences. The third one says, I hereby enter a plea of nolo contendere to the charge of prostitution. Is that correct, that you're pleading nolo contendere?
Yes, sir.
Now, just so you're aware, a nolo contendere is taken by this court as a guilty plea. Do you understand that?
Yes, sir.
All right. The rest of this big document is divided into 15 separate sections, divisions, or paragraphs. Each one is numbered. The first one talks about what punishment there is for this offense. There's a stack of little boxes, and each one talks about a separate or different type of punishment or class of punishment. There is a check mark that says you understand that you can be punished under what's called a Class B misdemeanor, a fine from $0 all the way to $2,000, and jail from 0 days to 180 days in jail. Were you informed and are you aware of that?
Yes, sir, I am.
I'd like for you to read number 2 for me, please. Can you read it where you're at?
No, I can't. I have nothing. Okay, here I am.
Number
I
2.
understand I have a right to a jury trial, a right to cross-examination of a witness, and a right to remain silent. I freely and voluntarily waive those rights.
All right. Is that a true statement?
Yes, sir.
All right. Now, have you ever had any mental health problems?
No, sir.
Have you ever been given or taken mental health medication?
No, sir.
All right. Number 4 tells you you're declaring that you're pleading nolo contendere because ultimately, after reviewing the evidence and hearing your attorney's advice, you think it's in your best interest. Is that correct?
Yes, sir.
All right. You ever participated in the sex offender registration program?
No, sir.
All right. Where were you born?
San Antonio, Texas, sir.
Okay. It'll reflect in the record that you are a U.S. citizen. Some of these paragraphs applied to you, some did not, but they were important. You did review all of these with your attorney, is that correct?
Yes, sir.
By signing this, you also gave up number 15, which says you have a right to demand a risk and needs assessment. By signing this document, and I see that you did sign it, you gave up that particular right. That's mainly for someone that's got problems and needs help, or that there's other factors involved that should be made part of the record. You're telling me you don't need that, is that correct?
Yes, sir.
Okay. The next document is a document with, again, the same identifying information. This one is titled Trial Court's Certification of Defendant's Right of Appeal. Again, there's a vertical stack of little boxes, and next to each one individually is a description of the right to appeal in different forms. The fifth box, which is shown to you here at the top, in there I declare this is a plea bargain case and the defendant has no right of appeal. Did you see and understand that?
Yes, sir.
The document does have your signature and that of your attorney. Now, the document I'm showing you now is, again, the same identifying information at the top. This one is titled Application for Deferred Adjudication. This is very important. Sir, you need to listen carefully, Mr. Ovalle.
Yes, sir.
Deferred adjudication is a very good bargain that your attorney has gotten for you. Your plea of nolo contendere is sufficient for me to convict you. But in this case, I will be honoring an agreement that you've made with the state. And instead of convicting you, I will enter or grant you what's called deferred adjudication. Another way, another word to just make it a little more clear is say suspended, or even better, postponed adjudication. If you live up to 100%, and I want you to hear me, if you live up to 100% of the conditions of supervision, then the case will be dismissed, and under Texas law, you are not convicted of this charge. I think you can understand how important that is. The conditions of supervision are going to be read to you, and you will sign them. There'll be no way you'll tell me later for any reason, oh, I didn't know what the conditions were. You will know, they'll be read to you, you will sign them. If you live up to those conditions, the case gets dismissed. And again, this is what's called a crime involving moral turpitude. So it is very, very much in your best interest to complete everything. Do you hear me?
Yes, sir, I do.
All right, now, if you screw up and you fail to live up to 100% of the conditions, or you refuse to do it, then the state can ask me to give you official notice and bring you in for a hearing. And at that hearing, depending upon the evidence, the information I hear, I can give you a final conviction that will follow you the rest of your life. If that were to happen, then you're looking at the full range of punishment, a fine from 0 all the way to $2,000, and jail from 0 days to 180 days. Are we clear?
Yes, sir, we are.
Very good. Now you're looking at what's called a personal data sheet. That's the only one that doesn't have the identifying information at the top. And it's quite simple. This is all of your identifying information. Where are you working, sir?
Right now, I'm with Mark Adams Landscaping.
And what do you do there?
We cut grass, lay sod, and do flower beds.
All right. So do you work full time?
Yes, sir, Monday through Friday mainly.
All right. And what is your income on a monthly basis?
The monthly,
That's simpler. Go with weekly.
weekly, it would be around 3 to 350.
All righty. So that's 14, about $1,500 a month.
Yes, sir.
Okay. And did you fill out the original on this?
I believe I didn't, sir.
You did not?
No, sir.
All right, I'll need you to come into court and sign that and fill all that information out. Are you married?
No, sir.
And do you have any children that you
Yes,
have?
sir.
How many do you have?
I have 2 children, sir.
How old are they?
19 and 17.
Okay. Legally speaking, I have to find that you have one dependent. Okay. Have you ever served in the military?
No, sir.
Okay. And do you have a vehicle?
No, sir.
All right. Then officially, we're going to look at what's called the plea agreement. That'll be loaded up in a moment, and we'll go over it. All right. This document is called plea agreement. It has identifying information of your name and the case number. It does not mention the court. The first 2 boxes will be marked by the court. The first one talks about the right to remain silent. And it explains it again, that you know and understand it and given up that right. The second box I'm having marked says that you are a U.S. citizen. Then the next section in bold print says defendant's acknowledgements. There are 5 little boxes stacked up vertically. Next to each one is a declaration regarding the different rights and protections that you have, that you're aware of, that for the most part that you have, you're giving those up. Is that true?
Yes, sir.
All right. Now, this next section checks off or shows what the charge is against you. This one says prostitution. The next section shows what you're going to do as far as this plea. Patricia. There's a check mark at the top there that says that you must appear within 7 days to provide a thumbprint required by law here at the court, okay?
Okay, yes, sir.
If the offices that you'll be appearing in are in the hallway behind the courtroom. Now, what is your official plea?
My official plea is the the no, that was the no content or the guilty.
It's nolo contendere, I believe.
Okay, it was that one. I don't know how to say. I'm sorry.
That's all right. It's in English, it's no contest.
Okay, no contest. I'm sorry.
Again, I remind you that a no contest plea is considered a guilty plea in this court. Is
Okay,
that
yes, sir.
understood? I could convict you on that now. Do you understand that?
Yes, sir.
All right. The court finds there's sufficient evidence to find you guilty, but I do not find you guilty. I am honoring the agreement that you have made with the state. The court grants you 6 months deferred adjudication, a $0 fine, the court will assess a $25 a month supervisory fee. Am I missing something on there?
No, Your Honor.
Okay.
No, sir.
All right. Mr. Ovalle,
Yes, sir.
don't mess this up. You got a good thing going for you that Ms. Valenzuela got for you. So this concludes this proceeding.